Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, how is it developing? Understanding the competition law and enforcement in Brazil. You know, outside the United States, antitrust law is actually known as competition law. And we often in the United States have a US-centric focus, but we also understand that there are some important jurisdictions, particularly the European Union is one we look to, probably the United Kingdom as well. But there are other jurisdictions, and one that has had increasing importance in recent years is Brazil. The OECD has recognized that the Brazilian competition law regime, quote, has largely been considered accessed. And particularly, quote, its cartel enforcement program is widely recognized both in Brazil and internationally. I think it's important for all of us who practice competition law, which is by its nature internationally, to understand how Brazil works. And today we are very lucky to have one of the leaders of the Brazilian Competition Authority with us today. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
All right. So, Anora, what are we doing today?
We're going to talk about one of the most exciting jurisdictions in the realm of competition law to me, which is Brazil.
Great. And who's our guest?
Our guest is the Honorable Commissioner Luiz Hoffmann, who is one of the most recently appointed Commissioner of CADE, short for the Administrative Council for Economic Defense, which is the agency entrusted with the sole responsibility for competition law enforcement in Brazil ever since, I believe, 2011 reform of Brazil's competition law. Commissioner Hoffmann holds a degree in law and also a doctorate, and has served the public in other roles, including at the Federation of Industries of the State of Sao Paulo as the director of the legal department and of the Young Entrepreneurs Committee, and also as a judge of the Tax and Fees Tribunal of the State of Sao Paulo. Prior to joining CADE, Commissioner Hoffmann has also been in the private bar, practicing competition law as a founding partner of a respected law firm.
All right, great. Well, let's bring in our guest, Commissioner Luiz Hoffmann. Welcome to our program.
Hello, John. Hello, Anora. Such a pleasure and honor to me to be with you here.
Honor and pleasure is all ours. Very welcome and very exciting, exactly as I said, to have you on the program. And as John has already briefly talked about, outside the United States, there are several jurisdictions that's very active and respected, and Brazil is among one of those. And that, in that sense, I hope just to ask you briefly explain how does the competition law and enforcement regime in Brazil works? How is that structured? Essentially, compared to other jurisdictions, would you dumb it down a little bit for us? Where does the Brazilian regime stand, and perhaps does it lean towards any major jurisdiction, including the United States, in terms of the policy and the priorities of enforcement?
Thank you for the question, Anora. Firstly, it should be noted that since antitrust law's origins come from the U.S., it's not possible to ignore that the U.S. does influence the development of antitrust policies worldwide, including Brazil. However, it's very important to know that while U.S. legal system is based on common law, in Brazil the Romanic-Germanic civil law prevails. These systematics are very different. This does not mean that jurisprudence is not deemed as important for assessing future cases in Brazil, but rather than statutes are highly regarded. As a matter of fact, CADE jurisprudence is always considered in our antitrust cases, especially considering the need of providing legal security for society. On the other hand, this doesn't remove the possibility of adopting new understandings in present or future cases, since markets are very dynamic and the authority should consider market stage at the time of its assessment. In all circumstances, the decision must be motivated and justified, especially if it changes the understanding of previous cases. In Brazil, free competition is a principle which foundation is expressed in our federal constitution, within its chapter that deals on the economic order alongside with the principles of free enterprise, free competition, social purpose of properties, and consumer protection. In the infraconstitutional level, antitrust in Brazil is based in our law from 2011, recently enacted. This does not mean that the antitrust enforcement in Brazil is this new, but it's an indication that our law has been in constant development in the past few decades, differently of what occurs in the US. In this sense, I think that we can observe that Brazil's antitrust legislation is similar to Europe's in some aspects. As an example, our competition law prescribes that there can be conducts that are either unlawful because of its object or because of its potential or actual effects in the market. Although CADE has existed since the 60s, its structure and attributions have changed significantly. The current law has made substantial developments for antitrust enforcement in Brazil, as we can see, for instance, by establishing the ex-ante merger control.
That's very helpful. I just want to highlight two things that you have mentioned. One is the weight of precedent seems to work differently in Brazil than in perhaps in the U.S. Here, all we talk about and all we fight about perhaps is the application of certain historical cases. And then another thing that's really important for our listeners is to understand the law in Brazil, the competition law in Brazil is in constant development, as you have pointed out. I remember I visited CADE and Brasilia when I was a law student, and I was shown actually a copy of the Brazilian Constitution, which is about 2 inches thick. Are you telling me the competition law in Brazil is also getting thicker and thicker like the Constitution in Brazil?
No. We have a law that's very small. We have, I think, around 60 articles around it. And it's because our system is different. We can compare the structure in the U.S., the legal system in the U.S. with Brazil. I think that's completely different. You have only one constitution. I lost the count about how many we had so far. We have almost the same age that the U.S. and Brazil about existing. And so that's very impossible to compare. But I think that our antitrust system is also different because it's composed by 2 different bodies. It's CADE, and we also have another one, which is the Secretary of Economic Monitoring. CADE, for instance, is a federal entity as well. It's linked to the Ministry of Justice, and it has the exclusive role of initiating, conducting, and running on antitrust cases in Brazil. And CADE is also composed by a general superintendence, which you call in Portuguese as SG, and we have our tribunal, like a court. And we have also a Department of Economic Studies and also an Attorney General's office. Therefore, I think that different than what we see in the US, our investigations are restricted to only one agency within the executive branch as administrative proceedings. On the other hand, it is distinguished from judicial lawsuits and criminal investigations, which are conducted by the judiciary branch. Therefore, CADE in Brazil is sovereign in conducting and running all antitrust cases.
That's very important. I have I think the 2 perspectives you have put us in is very important. For one is historically, there are other agencies that have been entrusted with powers to investigate and perhaps initiate certain questions about competition. And then now it seems like they're all they're all folded into the SG that you have talked about. We can go into, and we do want to learn more about that. But another quick follow-up is that we do understand the history of trying to enforce competition law is actually very long in Brazil. There were efforts that I read, according to the academic paper that I read, that's as early as in 1930s, and then throughout the history, 1960s, and then along with the history of Brazil as an economy, as a country that's opening up and towards more market-oriented policies. So that's very, very useful. I think perhaps let's learn more about how does the SG and the tribunal, which I believe is the two major branches within CADE, works. And then, John, if you have a comment, please do chime in.
The SG, as you mentioned, is, let me put it this way, is an investigatory unit. It is responsible for initiating, conducting, and not only conduct cases, but also merger control. So that's very interesting because you have two totally different kinds of works being done in the same body. When you talk about regard conducted cases, you have preparatory proceedings, you have administrative inquiries, which are developed into administrative proceedings according to the level of potential anti-competitive conduct elements. So SG investigates, and afterwards it concludes the investigation, giving a recommendation or either shelving the case or condemning the defendants. However, it's not definitive position that SG can give. That's the part and the role of the tribunal. When it analyzes all the investigation, all the defenses from defendants, and it clears and states what's going to happen with the persons in the case. The tribunal is going to rule in a definitive manner. And when we talk about merger control, besides initiating and conducting the proceedings, SG is responsible for running cases. So that's very different from conduct cases. If the case is unconditionally approved, then, as a general rule, it will not be forwarded for the tribunal's review unless the tribunal understands its ruling is necessary, called as a vocation. So SG judges, and it's okay if there is no antitrust problems. But even if it doesn't have it, the tribunal can say, "Oh, this case is important. It can be only for SG point of view. I need to rule it." So we in the tribunal we can decide to take any case that is on SG. But on the other hand, if the conclusion of SG is to approve with conditions or not to approve the deal, then it's compulsory that the case goes to the tribunal. So it's a mechanism about controlling. SG can do it. It can do it in a fast way. They are very specialized. But if the tribunal wants to make any control or wants to take a little look very deeply, it's also possible. So it's a very good mechanism about working together and being effective and being fast as well. And I think these dynamics have been working pretty well, considering that for these dynamics, our law gives us and inputs a Chinese wall, which enables the units to perform an independent assessment of the cases according to its own legal attributions, as I mentioned to you. Anyhow, both units communicate with each other in a view to exchange know-how, to fully comprehend markets, discuss assessment techniques, among other situations, because, as a matter of fact, it's only the cases are the same. So it depends on how it's going to be investigated and how it's going to be analyzed.
Commissioner Hoffmann, that's really helpful. And maybe just for our largely American audience, correct me if I had been thinking about this as you've been describing it this way. And if I'm wrong, please let me know. But I was sort of thinking about CADE as being similar to our U.S. antitrust enforcement agencies, kind of like our U.S. Department of Justice Antitrust Division or our Federal Trade Commission. And then the tribunal as being sort of like our courts, where, when the agencies go and prosecute, have a case, the case ultimately has to be approved by a court. I think the big difference is that the tribunal is actually a competition specialist court. They really, and that has been an area, I think, if you talk to certain of the practitioners, they will say that it's that sometimes the federal courts are general jurisdiction courts. We have very talented judges who try very hard, but they tell you they are not antitrust experts. And sometimes that leads to inconsistent decisions or changing of standards, and even political considerations being brought in. Wondering if I could get your reaction to that and how you feel that, whether you think it's an advantage to have a group of the arbiters being competition specialists.
No, I think that you really got the point. Our law really wanted to have a specialized court to judge antitrust cases. So that's very good because we have our own jurisprudence. So we have all the cases that were based. I mentioned about common law and the difference about civil law, but of course we, and especially me, I always look and study in my votes regarding the past cases because I'm here for more than a year, but I won't be forever, and I have to give some legal security to the market. So I cannot say, oh, no, everything that was done so far was wrong, and now I'm the illuminated one, and I'm going to decide as I want. Oh, of course not. I'm a commissioner, but I belong to a body. I belong to the tribunal. So we have to give legal security to the market, and we have to deliver what is expected according to my point of view, according to my independence as a commissioner, of course. But I think that's very... And I think the market in Brazil and CADE has been gaining a lot of awards, and because we are specialized and we are trying to deliver our services to the society in a very good way, taking consideration the welfare of the society.
I think it's actually common understanding, not just within inside Brazil, but also internationally, that CADE is doing great work, especially within the realm of cartel enforcement. I'm going to go into that really quickly, but just a very quick reference. How many cases does SG bring, just roughly, each year? And then how many cases does the tribunal decide each year?
Since we have a lot of small cases and they don't have any problems, and of course everything begins in SG. Of course, SG we have more cases than the tribunal, which I'm very comfortable because they are very technical and they have all skills and tools to judge cases and to rule them. But so far in 2020, we had, even during the pandemic, almost 500 cases. And around 430 were taken by the SG, and around 60 and something were taken by the tribunal. And this number is very similar to the last year, even now whether during the pandemic, and CADE has been able to show itself as very effective, also even though we are during the pandemic. So the same cases, almost the same number that we had last year, but we were more efficient and more quicker than last year. So that's very nice to say, and for me, I'm very honored to be in such an institution that is delivering a lot of good service to our country.
That's definitely an impressive record that CADE is maintaining and perhaps even improving. And then coming back, as I already alluded to, cartel enforcement is one of the most highly praised area that CADE has been doing. Could you tell us, how does CADE essentially do it? Is there? I heard something about the Brain Project, and perhaps something else that had something to do with data collection that would enable the agency to better to have early detection or initiate investigations. Could you tell us about that, or something else related to that CADE is doing in terms of cartel enforcement?
I think CADE has been taking a lot of initiatives. The first one I would like to share with you would be advocacy. CADE has been promoting a lot of competition awareness in Brazil with events and webinars and a lot of events. I think that's when you give awareness to the people and to society, everybody knows what cartels are, and it's a very good way to fight. But I think the second one would be the leniency programs. I think that nowadays it's very difficult to detect and to prove the existence of cartels. So when you adopt a very good program, a leniency program, I think CADE is showing the society that this is a way of fighting cartels. It's effective, and it's also encourage companies to pursue agreements. Otherwise, they get severely punished. So I think that's a very other good point. And I think about cooperation, fostering cooperation with local entities, Brazilian ones, and also all over the world. I think that's a very good way about fostering and taking good actions against cartels. You talked about the Brain Project. That's another good example. It's a project that aims to increase the use of analytical quantitative data for assessing and fighting against cartels. And it's all connected to intelligence artificial intelligence. So I think that's it's very innovative as well.
Has there have been some reports, some cases involving Brazilian companies that have made national presses more in the anti-corruption space. But has there been an increased awareness among Brazilian companies about the importance of compliance, brought out by some of the large press, but also by your efforts in teaching about cartel? Have you seen companies learn more about compliance, and are you doing anything to encourage them to develop compliance programs?
Excellent question, John. That we will do some kind of agreements with companies about leniencies, and also after leniencies, when other companies come, if they show to us that they have good compliance programs, if they are adopting it, we can give a little bit of discount for penalties and punishments. So that's very enforceable in Brazil about how we are adopting, not only by advocacy, when you show them that you should do it because it's better for you, for your companies, but also when you're going to pay, if they have and they prove that's a very good compliance program, they can pay less for the penalties they would have in a proceeding.
I want to trace a little deeper into what has contributed perhaps the success of CADE in cartel enforcement. What do you think have been the most important things that could enable the agency to do what it has been doing? Perhaps does it have anything to do with the broad authorities that the agency has, perhaps doing down rates, something like that, and perhaps the ability to work with other agencies as well?
Yeah, I think, as I mentioned in the last question, I think the number one for me would be the leniency program. I think that's the most important, and it was giving much more value to our enforcement. But of course, when you do collaborative work with other agencies all over the world, and you also use down raids, that's very important because, as you know, detecting and proving the existence of cartels, it's very difficult. So when you have a good program of leniency, when you use the down raids, and also when you have collaborative ways of working with other jurisdictions, I think it's very important.
That's very, very important. And you already mentioned that the cooperation with agencies inside and outside Brazil. Could you tell us a little bit about the international collaboration effort that CADE has been making?
We have a lot of agreements with other antitrust agencies. For me, I studied in Italy for my PhD, so we have I was responsible for our president to receive the agency from Italy in order to discuss cooperation. So we have, I don't know how many agreements we have with other antitrust agencies, but we have a lot of, and people from CADE go to these agencies, and people from other agencies come to CADE in order to exchange information, in order to exchange collaboration in specific cases as well. So it's very difficult to explain how it works in a broad way, but it really happens on a regular basis in an individual manner.
I'm definitely a witness of that part of that effort. As I already talked about, I visited CADE with privilege when I was a law student, and then I was very impressed by how the people that I met and how the agencies sort of set up. That's another thing that I want to highlight. It seems like CADE is making effort to be more transparent. At least with the hearing rooms with the tribunal that I visited, there are fully equipped, televised equipment that would enable the public to have access or view the hearings. Is that true? Are all hearings open to the public or televised? Or are there any other efforts that the CADE is making to be more transparent?
I think I didn't mention before, but in a collaborative way of working internationally, CADE is also part of the OECD competition committee in OECD. It's a definitive member since 2019, where I think is also a recognition about how we are working. And it's true about you were talking about transparency. Transparency in Brazil, it's very important for us. All ruling sessions are public. presence is allowed as well in CADE's sessions. And during this pandemic, we are broadcasting on the internet our sessions. So I have to stay here in the camera the whole session, paying attention and discussing with all the other commissioners. That's very interesting because that's a way of advocacy as well. When you are public, you make your sessions, you are telling the society, come see how we work. Everything is public. You can discuss, you can see, and companies can understand how they should act in the future. That's very important for advocacy as well.
That's very, very helpful. And I do have two more sort of hot topics that I want to mention without letting you go into our more fun, personal or curious head section. One is that tech antitrust. Everyone's talking about it, and it's hot in every jurisdiction that we're paying attention to. Are there any specific concerns or even actions already brewing, perhaps, for a stricter scrutiny of activities done by tech companies, or any concerns, platforms, digital, or just tech in general?
That's a very important question. I think the whole world is discussing about these issues. We are seeing what's happening in the US with a lot of new filings and things that are happening. And for us, that's not different. On behalf of CADE, I have prepared on a few months later ago a paper about abuse of dominance in digital markets in a view to contribute for OECD 2020 Global Forum, which is taking place in December 2020. And again, this contribution is public and can be accessed online. And we took in consideration in this topic that digital markets are extremely dynamic. And they have specificities that might favor cases involving abuse of dominant position. In this way, the antitrust enforcement experience in Brazil and abroad really indicates that the digital market's characteristics present several challenges in the competition review process. For example, by making it harder to define relevant markets and also to determine whether a certain platform consists of an essential feature. I think these are all very current discussions that we are having all over the world. Moreover, the issue concerning when and how the authorities should intervene in the markets is not easily solvable, since it's necessary to be cautious when coming up with an effective remedy to avoid discouraging innovation, which would in turn be harmful to consumer welfare. Nevertheless, in Brazil, the prevailing understanding is that such challenges do not imply a need to make change to legislation at the moment, since we are civil law-based, or that abandoning current consumer welfare standards is desirable. Anyhow, CADE has been extremely alert as regard to this topic, having initiated and conducted investigations on tech companies in the last years.
That's very, very helpful. And I agree with you. The cautious, the point about being cautious about remedies and how its impact on innovation is definitely worth considering and important. Another hot topic, which sometimes people don't like this term, called hipster antitrust, which is essentially describing the phenomenon or I guess, recommendations for actions to have competition enforcement considering a broader set of issues. It's difficult for me to discuss this, and John knows the background. Perhaps John would want to chime in.
Yeah. Yeah. So, and I'm one of the people who hates the term hipster antitrust, but the idea, I think the idea is a move away in the U.S. from the consumer welfare standard towards a more historic standard of preventing companies from becoming too large. And I think the question that we have is how, if at all, has that philosophy influenced CADE? The philosophy that we'll say is the debate between those advocating for a consumer welfare standard and those advocating for a standard that tries to protect any one company from becoming too dominant.
Yeah, and concerns for labor, small businesses, and perhaps even democracy.
I think this is a very big coincidence because I wrote an article very recently in English, and I will send to you so you can see how we see that in Brazil. But we note that CADE has been focusing its approach, also in the consumer welfare standard, scrutinize the cases solely under the competition perspective. Our law, our system is based on the civil law, as I said a lot of times today here with you. So we cannot be and put more values and more issues that the law doesn't allow us to do it. So we have to be restricted to the point and to the values that our constitution gives us, even though it's such big, as you mentioned. So issues as industrial policy, labor, environment, innovation, businesses, they have been only considered within the limited extent of the impact in competitive issues, but only if, but not as a main reason about to rule the cases. I believe the CADE has a well-defined role and has also plenty of legal technical research of fulfilling it. Even consider the challenges faced by the new market dynamics as the digital economy, as I mentioned before.
I want to shift gears just a little bit and ask you some questions about maybe how you think about information that influences you, particularly internationally. There has been in a sense, the U.S. system and the European system have diverged in some ways. Both protect obviously competition law, but they become slightly different systems with slightly different values. Again, you could argue that the European system is more focused on is more open to the quote unquote hipster antitrust type approach than the U.S. system. What Commissioner Hoffmann, what do you read that influences you internationally? Do you look at decisions that are coming out of different authorities? Do you read articles by scholars? What are some of the things you look to learn about what's going on outside of Brazil?
That's very interesting because I was not at the tribunal so far, but we had the Google shopping case, which had a decision in the US and another one in the EU. And it was very interesting because when you took a look at the decision, both decisions from US and UE were analyzed by taking in consideration what would happen in Brazil. So we analyzed the US case, we analyzed the EU one, and we said, oh, okay, that's what happened. Because we are a global market in some way, of course, that we have all implications. The relevant market is the Brazilian one for our case. We cannot judge according to other markets, but we took in consideration, we discussed it, and as a matter of fact, we were more related to the U.S. point of view. Even we are based on civil law and you are in the common law, we made our analysis according to our law, according to our system, but the conclusion was, even though we are more similar to EU as the system, we were more connected to the decision made by the US. So that's very interesting, your question, because we have our independence, of course, we have our jurisdiction, but we take in consideration not only cases from other jurisdictions, but we also take from other places in Brazil for other cases that are judged. For example, the criminal ones and so on. It's not because if a company is going to be condemned in the criminal section, the branch, it doesn't mean that it's going to be condemned in CADE, but we take everything in consideration so we can have different points of view and we can have our own decision. That's very interesting.
And sort of a different follow-up question. I want to ask you, what makes looking at it from the perspective of a regulator, you have advocates come in front of you. What makes an effective advocate, an effective lawyer, coming before to state his or her case on behalf of a client? What are some of the things that you found advocates do that influence you positively, as well as what are some of the things you wish they didn't do?
That's very interesting, John. I used to be a lawyer. I will become again to be a lawyer. So when you change your hat, that's very interesting because you see what you were used to doing, and now you're going to imagine how you're going to do it because I have a different hat. So how am I going to do in the other side? What I do like is when you are transparent. You need to be to say the truth to the authority, because if the authority discovers that you are trying to hide something, that's going to be very, very worse, because maybe the authority I'll say, oh, I cannot rely on anything that these advocates told me. What I'm going to consider? Can I consider something? So I think the first thing, you have bad points that you shouldn't say, but in order to be transparent, I'll say, I have these points, these things that are not very good to my client, but they are not so important. I have more things that are important. And I think that the lawyers have to be very objective. You know, when you start to talking according to law, according to cases, that's very nice. But we are going to judge this case. And this case, what's going to happen? What happened before? What are the main issues? So I think, because if you talk too much, then the authority loses attention what is more important. So you don't have to know to show knowledge. You don't have to. You have to you have to help the authority to see what is more important, and much more important, to work in a collaborative manner. If you are being humble, if you are saying, oh, I have this problem, I don't have this one, and I'm here to collaborate, can I clarify anything else? So I think that's the most important, to work with the authority in a collaborative manner.
And I think that's how it would work here in the U.S. as well. I think, my view, the most effective advocates before our agencies are the ones who, every time they're in front of the agencies, tell the truth and, never are, as you say, are transparent, share, and give an objective story to the agencies. The first time an advocate deviates from that is their next case, they're going to be treated with slightly less trust.
Sure.
So I think it's probably the same. Shifting gears again, if you had to give advice to young lawyers who want to get into competition law, particularly competition law in Brazil, what would you suggest? Are there things they should do, experiences they should try to have?
I think in order to answer you, John, I think when I say what I would say to young professionals, I tend to look what I did, so to see what I did right, what I did wrong, because we are not 100% right all the time. So I think I had a very well balanced career. I worked almost 20 years as a corporate lawyer, and I had the opportunity to study different markets. I led a law firm. I also didn't work only in my law firm, but I also participate in different bodies, such as bar associations, what we're doing here, Federation of Industries. But I never stopped studying. I never stopped trying to develop my skills and my knowledge. And I think I will never will, because I will never be perfect. So I have always to develop myself and to do that. And I also did that abroad, not only in my country, in order to have different point of view and different perspectives. And since now I have a different perspective as an authority, and seeing things in a different perspective, as I mentioned in the last question, I think I'm changing my way of view. So since I'm still under 40, I'm about to complete 40, and I still consider myself as a young person, my advice, and which is what I have always tried to achieve, would be never stop studying. Never stop writing articles. I think that's the thing that you should never stop doing. But in order to answer your question and going to my answer, I think always, as I mentioned before, work in a collaborative manner, not only with authorities, as I mentioned, but with your colleagues, with your staff, with your clients. I think that's much helpful to all of them. And always try to see things in a different manner, because your point of view is not the only point of view that exists. So always consider, wear the shoes of the another one. I think that's very important. How the authority is going to see that. And I think that's something, in order to achieve that, if you can participate in different bodies, if you can exchange knowledge and networking. Network is not only for getting and meeting people, it's also for exchange knowledge and trying to work in a collaborative manner. I think that would be my advice. Trying to correct some things that I didn't do, and that I also did.
Okay, and last question before we get to our Curious Hat round. This is going to be the hardest one of the program. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
That's very nice. I think I have some hobbies and some values that only my close friends and my family are aware. I'm very passionate about sports, football, basketball, tennis. But I think traveling and studying languages, for me, that's something that I really like. It took me to study abroad. That was very nice. Nowadays I'm fluent in English, I think. Portuguese.
More fluent than I am, actually. But yeah.
For Portuguese, Spanish, and Italian. But I continue studying, and my aims now are to be fluent in French and German. I'm reaching the intermediate level, even though I can say good morning and so on by now. But it's something that I think nobody knows, and I don't know if I should say that. And when I was a child, I studied more than 10 years classic piano and guitar. It was very interesting. It was classic music, even though I consider myself an eclectic person related to music. That's something that I really like doing, and I think that really developed myself as a person and in a lot of different ways. But I think that family. I'm sorry, John. Please.
No, I was just gonna ask you, is there a piano or a guitar nearby you right now?
No, and if there would be, I would say that there isn't, because I would be prepared to play it.
I was going to say, well, the next time we'll have you. Next time you see you in person, we'll be sure that there'll be a piano and a guitar, and we can have a performance.
It's easier to have one of your associates to carry a guitar, perhaps not a piano.
But no, we are isolated. We are in the pandemic, and unfortunately, we can have a guitar by now.
Well, with that, let's go to our final segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
In times when we are together, I have an actual hat, and in the hat are actual questions, and people pull the questions out of the hat, and then we read them. When we are not together in these times, I have a list of questions. They are numbered from 1 to 25, so I'm going to ask you to choose a number between 1 and 25, and I will read the question that corresponds with that number.
23, because 23. I like Michael Jordan.
Okay, Michael Jordan. Okay, what is your favorite special occasion food or drink? What do you like to eat when you have a special occasion, or what do you like to drink when you have a special occasion?
Well, since I lost 20 kilos during the pandemic, and I know how that happened, my wife tells me that it's because I ate her food during the pandemic, so that's very interesting.
My wife would take the position that I gained 20 kilos during the pandemic by eating her very good food, and I would support that. I will publicly say.
But that's not me that I'm saying. She's saying, so I can tell you that. But I do like pizza. And a pizza not for a lot of different occasions. It doesn't have to be a special occasion, but since I studied in Italy and I'm also descendant, not only because you see my name, I'm Hoffmann. I'm a Hoffmann, but I'm descendant of Portuguese, Spanish, Italian, and German. So we say here in Brazil that I'm a very really Brazilian guy. So
so pizza. What toppings do you like on the pizza?
I do like the margarita ones that which come with tomato and cheese.
Okay, so on a special occasion at the Hoffmann household, we're having pizza and maybe birthday cake.
A birthday cake will be nice for my 40s.
Okay, we'll have to send you a cake, and I will tell you that's how it goes down in the Roberti household as well. I think we're out of time, so Commissioner Hoffmann, thank you for being with us, and until next week, we will see you all on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.